considerations. Next slide, Kev, please. For those of you that may have missed the first couple of webinar sessions that we did in January and February, those are both available on the Champion website. The link is on this slide deck that will be sent out to everyone at the conclusion of this webinar. So if you want to watch the prior ones, feel free to do so. During this presentation, if you have any questions, please type them into the question panel. We will be taking questions, and we hope that we have interactive input. We've coordinated some questions and gathered some questions based upon feedback from some of the attendees. But hopefully it'll be very beneficial, and if you, like I said, if you have something you need, just type it into the question bar. Next slide, please. For those of you that have attended previously, I'm Debbie Brenner. I work for Champion Solutions Group as their Information Security and Privacy Officer, and I also run the professional services organization within Champion. We also have with us today Christopher Bergio, who is our insurance consultant, and he's the Vice President of Property and Casualty at Marsh McLennan and Agency. Chris, you want to say hi to everyone?
Good afternoon, everyone.
I thought I'd let everybody hear our voices. So next we have John Nidis. He's one of the premier data and governance and cybersecurity professionals that's been in the business before it was even cool to be in the business. And he's joining us from Kilpatrick Townsend, where he's the co-leader of the cybersecurity, privacy, and data governance practice. John, you want to say hi to everyone?
Hi, everyone. I'm still not cool, but this is my voice.
Thanks. And then finally we have Alfred Cycli. He's a partner at Shook, Hardy & Bacon, and he founded the firm's data privacy and data security practice group, and he's also been in the industry for an extremely long time, helping customers and focusing on the data security as well. So Al, go ahead and say hello to everyone.
Good afternoon, everybody.
So it's great to have such an experienced group of people on the phone today. I hope all of you will take advantage of it and pick their brains, ask them questions. Don't be afraid to. That's what they're here for, and hopefully some of the topics that we've chosen will pique your interest even further. As you can see on this slide, all of our LinkedIn contact information is right there for you to access, as well as some of us have Twitter accounts. If you're interested in following us on Twitter, you can link to it from our LinkedIn. To get started, we are going to start the process today with a couple of poll questions. I'd like to get them out of the way up front so that we can just continue to flow through the presentation smoothly. So a couple of three easy questions, yes/no questions for everybody today. First question I'd like to know is, does your company currently have a cyber insurance policy? Please select a yes or no, and Kev, let us know when our percentages are getting up there.
We're at about 40% right now, or 50%. People are answering very quickly. We're kind of stuck at 50%.
Anybody else going to answer?
60. And that's about all we're going to get.
Okay,
So
what are our percentages there that's showing?
70% of the people said no, 30% said yes. Now it's 67% said no, and 33% said yes.
Okay, that's perfect. Thank you. Of those 33% of you that said yes, for those of you that have it, have you ever had to file a claim or submit a claim against your cyber insurance policy? Yes or no?
So far, all no's. I haven't had a yes yet.
Okay. Perfect. We'll close that one out. And then the final question, it says, have any of you on the phone ever had to notify or engage law enforcement or a forensics team due to a breach to assist you with resolution and as possible criminal filings as needed? Answer yes or no.
Right now, 80% no, 20% yes,
Okay, perfect.
and that's with 65%.
Perfect. Thank you, Kev. So interesting statistics. I think that hopefully after our topics today, those 67% of you that currently do not have cyber insurance will understand the importance of cyber insurance and the reasons why it's a good idea, and hopefully Chris and the team can answer, any specific questions you might have. And like I said, any questions, put them in the question box, and Kevin will let us know when we have some questions to go. So let's move forward real quickly on Champion. Next slide. I'm not going to read the slides to you. It's just our standard deck that we put in our presentations about the 5 areas where Champion focuses: data center services, cloud and virtualization, security, data management, and services consulting. Further information on all of that can be found on our Champion Solutions Group website, so feel free to check it out there or reach out to me directly after if you have specific questions. And to make it very simple today, next slide please. We've kind of narrowed down the panel discussion topics into 4 areas. And I just decided to put them all on one slide, and we'll go through them and as far as the flow, open discussion until questions are interjected, and try to keep it moving along that way. So to get started, I'm going to throw the first topic out there at Al and tell him to just cover with us some of the trends in the breach notification laws and what he's seeing as far as cost litigation and other considerations and other comments on things that he has. So Al, go ahead, and everybody else feel free to chime in on the panel when needed.
Sure. No, absolutely. So, we're seeing a few trends now in the breach notification laws area. There are a number of states that have changed their laws. We have a new state that just recently added a law, the breach notification law. And so there have been a few different trends. First trend that I've noticed is that the expanding definition of what is personally identifiable information. And this is, of course, important because a breach is only a breach, at least in terms of the legal definition of it, if the incident affects personally identifiable information. And the definition is now expanding to include things like biometric information, and then also usernames and passwords. Those are a few states now are including that within their definition of personal information, personally identifiable information. Think about how often you use a username and password on a daily basis, whether it's at the office or at home. That could all be considered now personally identifiable information. The other trend that I'm noticing in breach notification laws is the shortening of the time period for sending out notification. We're seeing 14 days in Vermont that you have to notify the AG's office. There's a new EU law going into effect next year that requires notice within 72 hours. In New York, there's a bill that's being considered that would reduce the time for notifying the state and affected individuals to 5 days. And even in Florida, we amended our law a couple of years ago and cut it back from 45 to 30 days. So that's one trend. Another trend is, I don't know if I would call this a trend yet, but it's an interesting quirk because only Florida has it, to my knowledge, and that is a requirement that you notify if you're not notifying. And to explain that, basically what it means is that if you have an incident and you determine, for example, that there was no risk of material harm to any of the individuals whose information was affected and they're all Florida residents, then you still have an obligation under the Florida Information Protection Act to notify the Florida AG's office that you are not notifying anybody and that you've made this determination in conjunction with law enforcement. So that's just something to keep aware of. I think a lot of people overlook that requirement in the Florida Information Protection Act. Another trend is that we're seeing that more states are requiring notice to the state AGs in addition to the affected individuals when sending out notice. More states are adopting some secure destruction laws that require you to securely destroy personally identifiable information when there's no longer a legitimate business purpose for maintaining it. With respect to some of the costs that you can expect to incur if you suffer a breach. You can certainly, one of the first costs that you will incur will be the cost of a forensic firm, to investigate the scope and the cause of the incident, to help remediate the incident. Depending on, of course, the nature of the incident, if it's a cyber attack, you can certainly expect to incur that sort of a cost. Cost of bringing in outside counsel to give you legal advice on your notification obligations and to help direct the incident response. Also, the cost of putting together a call center. The call centers can range anywhere from 50 to 150 or even more thousands of dollars because it's depending on the number of people who are affected. Also, sending out notification. If you've got a big group of people who have been affected, and you need to hire a third party to send out the notice, you're looking at $1 or sometimes $2 a page. You send that to a couple 100,000 individuals, that's going to add up really quickly. And of course, credit monitoring, to the extent that you want to offer credit monitoring after an incident, and it can be a good idea to do that. It's not necessarily legally required, although in a couple of states it is required if the type of information that was involved included Social Security numbers. So those are some of the cost items that you have to think about. Litigation, on the litigation front, there's a few kind of trends that I'm seeing there. I mean, with respect to, it used to be the case that a lot of these class action lawsuits that were filed by individuals after they'd suffered a breach were dismissed for lack of standing. And then that slowly changed over time, I think anyway, to the point where now plaintiffs at least have a 50-50 shot, if not better, of getting past the motion to dismiss on standing grounds. There have been a couple of decisions in the last year or two, Neiman Marcus, P.F. Chang's, the Adobe decisions, that all where the court held that even the mere risk of harm to the individual may be enough for them to demonstrate standing and to move past the motion to dismiss. The reason that's important is because most of the time when a case gets past a motion to dismiss, it tends to settle, and it can settle for potentially millions of dollars. So one area is in litigation are these class action lawsuits brought by individuals. The other area are class action lawsuits now that are being filed by financial institutions, and those are having significant success. So think, for example, about the Target case. You have these individuals who filed class action lawsuits against Target claiming that they suffered harm. Target pushed back and saying, no, if you didn't, to the extent that you had any fraudulent charges on your credit card, those were reimbursed by your bank. Well, now you had all the banks coming back and saying, well, yes, and we reimbursed these individuals, and so we are suing you, Target, because you didn't adopt reasonable security measures that would have prevented the incident from happening in the first place, and so we suffered hundreds of thousands of dollars, millions of dollars in reimbursing individuals. So to put it in perspective, the Target class action lawsuit by individuals settled for somewhere in the neighborhood of $10 million, and that's actually under reconsideration right now. But the class action lawsuits that were brought by the banks totaled over $100 million. So that's another area to think about, especially in the retail sector. The last thing I want to mention is this new legal theory that we're seeing out there that argues that just a mere vulnerability without a data breach may be enough to create liability. So in the case that I'm thinking of, it's a case called Shore versus Bell & Johnson that was filed up in Illinois against the law firm. And the plaintiffs there argued that the law firm had vulnerabilities in its website and in its systems that would have allowed a hacker to get in to potentially access sensitive client information. There is no dispute that no hacker ever got in to that system. There's no hacker ever accessed it. There was never a data breach. But the fact that it was vulnerable, the plaintiffs have argued, was enough to make the law firm liable, and they should have to pay some form of damages. The case was dismissed, but not on grounds relating to the merits of that argument. So I think you could see more lawsuits filed on that ground alone, which is very scary because most companies have vulnerabilities. It's just a matter of being able to identify what they are. So those are some of the trends that I've been noticing.
That's great, Al. This is John. And along the lines of that last one, we're going to see an interesting case come out of the Federal Trade Commission this year, or come out of the appeal from the FTC's decision in LabMD that's going to be on that issue of whether, in the context of Federal Trade Commission jurisdiction, there is that vulnerability alone is a basis for likelihood of substantial injury under their statute. They're very active, or have been very active. Maybe less so under this administration. But the thing I wanted to add, the main thing I wanted to add, which Al alluded to a little bit, is the rapid expansion of breach notification around the world. I'm dealing with a breach right now in 57 countries. I'm notifying in 57 countries. And so those of you who have global operations, you need to be very careful in this area. And as those of us who've been dealing with breaches back since the beginning, since 2005 know, what happens with regulators, and that's the main focus overseas, is that if regulators are used to breaches, they tend to not punish you for having a breach because they recognize that breaches are happening all the time. They tend to punish you if you don't respond in the right way to the breach, and if your preparation and your security wasn't very good before the breach. So those things are what seasoned regulators punish you for. But the thing about all these regulators all around the world is they're not seasoned yet. And so you're facing, as Al mentioned, the 72-hour requirement under the GDPR, which goes into effect across Europe in May of 2018. But it's being copied in other countries as well. And the 72-hour requirement is there in this country for those of you who are regulated by the New York Department of Financial Services, which includes insurers who serve people in New York as well as banks. So it's a big deal for insurers, if any of you are that. A completely new level of security regulation. So those are a few additional things in addition to Al's good summary.
So a question I have is, I'm just one lowly person in my company, working and responsible for this with so many different laws across the states, different laws across the companies, different notification requirements. What's the best recommendation to stay on top of all that? I mean, John, I know you said you're helping with the notification of 57 countries. How did that ultimately end up at your feet to do that?
Well, some of us have been, lying awake night following all of this stuff since 2005, and, we've got to be good for something, and so we're good for this, that we know what the requirements are, we follow the developments, and we're able to educate the regulators as we educated the attorneys general over the years. So I think the main thing is, unfortunately, we've got this ultra-complex system. In this country, we've got an incredibly complex system. These laws, and as I should emphasize, because Al, may not have let you know just how complex some of these laws are becoming in terms of the combination of elements you've got to deal with. For example, you don't need the name anymore. In all the states. It's phrased differently in every state. So it's like a game of three-dimensional chess if you haven't played it. And there are people who say, oh, now that the Republicans are in charge of both houses and have the presidency, they're going to do a national law. Well, every time anybody's tried to do that national law, the AGs have pushed back. They've said we like our power and our complexity and all of that stuff. So we'll see how that goes. I heard optimism about it early on, but I haven't heard anything about it lately. So unfortunately, we're going to be dealing with this kind of complexity at the state level and at the international level for a while, I'm afraid. And breaches are just going to become more and more plentiful, as the New York AG just said they are in New York.
And Debbie, to your question, I think maybe one sort of practical piece of advice, may be to start with taking an inventory of the type of information that your organization is collecting. It's not necessarily easy to be depending on the size of and the nature of what it is the organization does. But once you get that, then you have a better sense of, okay, well, which laws govern me and what do I have to do under those laws? And then, you want to look at figure out what are the most stringent requirements. What jurisdictions am I regulated by that have the most stringent requirements? Because if I meet those, I'm good on the others, right? So, for example, if you're governed by states like Connecticut or Massachusetts or California, Vermont, those are ones that have some, or even Florida, have very specific requirements. And if if you're meeting some of those, you're going to meet the other state jurisdictions as well. Of course, the challenge is what you collect today may be different than what you collect, say 6 months from now even, or a year from now. So that can change. It is challenging, and I think to John's point, you've got to use a resource that really knows this area and whose job it is to stay on top of these things all the time.
Yeah, on the security front, it works to look at the high bar, as Al is saying. On the privacy front and some of the other information fronts, it's hard to do that because there are sort of conflicting requirements that on a state-by-state basis, and they're continuing to pass these things. So, but the high bar works in security for sure, Massachusetts has been sort of the high bar on security requirements for now since 2008, actually, oddly enough. Although there are some additional ones to consider in some of the other ones.
Yeah, for myself being in the industry, sometimes there's just overload of information and it's too much and you can drown by it. So Kevin, do we have any questions from anybody in the audience regarding this topic?
Sorry, I was on mute. No, not yet. We don't. I know that one of the things that we had people ask us before the webinar started was, for the lawyers on the panel, based upon your experience, what is the one recommendation you would give attendees to proactively protect themselves from potential breaches and related litigation?
Oh man, I've got a long list that just kind of started in my head. I'm trying to think which one of those would I pick. Encryption. I'd start with encryption in terms of a technical safeguard. I would say encryption. I'd say encryption because the law actually provides you with protection from having to send out notification in case of a breach if the information is encrypted, assuming, of course, the hacker doesn't get to the key that would be used to unencrypt the data. So encryption is important, and it's just, I'm seeing it, and John, I don't know what your thoughts are on this, but I'm seeing it as almost becoming like the standard for what companies should be doing with respect to how they secure sensitive information. In terms of a minimum, I'm seeing encryption across the board, and it's easy to just say encryption. It's harder to implement it because you've got different types of encryption, and you have encryption of data at rest versus encryption of data in motion. But to the extent anything can be encrypted, it can really help when an incident occurs. If you lose a mobile device or a laptop or anything that contains personally identifiable information on it, if the device was encrypted, then you don't have to send out notice. And the reason that's there is because the law assumes it's safe. It's been encrypted, and it's very difficult to break into an encrypted device.
Yeah, that's very well said, and it's quite true. But and the thing to bear in mind, though, is that all encryption has decryption keys, and the way in which all these breaches happen, including 5 that I'm working on right now, is that somebody gets an encryption key, basically, and they get an administrator password, for example, and that gets you right in. And so some of the laws are beginning to change so that they emphasize that there's no so-called encryption safe harbor if the password was breached, or it didn't meet certain standards, and so on and so forth. In addition to encryption, for another one, think about separation and not having certain stuff that you don't need. There's nothing more safe than that. So with those of you who are merchants, tokenization and getting the stuff, getting the dangerous stuff, the stuff that is in scope for PCI DSS security standards, out of your organization and into a secure place. You can separate the social security numbers out from where you have the rest of your customer golden record. So your customer golden record is no longer maybe notice triggering, even though in this world of targeted breaches, and we'll talk about this a little toward the end, your competitors will be after your customer golden record, and they're more focused on that. You at least won't be dealing with a notice triggering breach. The other thing that I would say to keep this realistic is we're living in the age of response. If somebody wants to break into your systems, they'll break into your systems, and I mean if they've got any ability to do it, and there are so many thousands of organizations and people out there who have the ability to do it that you just have to be ready for it. And you have to have a good response plan. So I would always say, as a first thing to consider in the context of security, make sure if and when it happens, and I would say really when it happens, that you're ready with a good response plan.
And that's a perfect segue, and one of the next quarter's upcoming Cyber Threat Thursday webinars is going to be focused on incident response. So just a little tip for those of you on the phone to keep your eyes open for the date and time for that one. We haven't finalized it yet, but that's one of the feedbacks from the attendees from prior for what they would like to see is a focus on incident response. So that's heading that way. So awesome information, you guys. Chris, from a perspective, you heard John mentioned, 57 countries. Al mentioned, the class action suits, all the dollars associated with the cost of notification, the credit monitoring, credit reporting. Tell us a little bit about what you're seeing from a cyber insurance perspective and the considerations that we should be thinking about.
Sure. So most companies can't afford the upfront costs associated with a breach, and this is really where the insurance comes into play. So I'm going to start with a couple of things. First, I'll start with an overview of we'll call it an a la carte menu that's available in the insurance marketplace. And then I'll jump into a few other considerations that are not typically on that menu, but things you should be thinking about when considering cyber insurance. So at the highest level, when we look at this menu, there are two types of coverage. There's third-party liability and first-party coverage. Third-party liability, pretty straightforward. This picks up the cost to defend and pay on your behalf when your company is liable. And this is really where cyber insurance was founded. So within that, there's three types of coverage. There's privacy, network, and regulation. Privacy, companies have responsibilities. I think Al touched on this before. When you're storing private information, be it healthcare information, be it personally identifiable information, or even private corporate information, there are responsibilities attached to that. And if you are somehow negligent in keeping that information private, you're more than likely going to be sued and held liable for it. And then what form is the information in? Is it digital or is it a paper form? And not all carriers or insurance policies are going to cover both. Next is network security. So your company might inadvertently spread a virus or somehow be responsible for some other company's breach. That's a different type of coverage, and that's also available in a typical cyber insurance menu. And then last on the third-party liability, regulatory action. Both of the gentlemen that spoke before me talked about the FTC, the Attorney Generals, all types of states having an interest in this sector. And I can tell you it's incredibly expensive to defend yourself against a room full of government attorneys. On the other side of the policy, we have first-party coverage. And this pays the costs that your company incurs following a breach. So reimbursement costs. When that call comes in and you're told that there has been a breach, you have to figure out what happened and you have to stop the bleeding. And that can be very costly. Next, business interruption can be picked up. So this covers the loss of sales that you might incur following a breach. Now think denial of service, or I don't know about you all, but if I walk into my office and I can't access my computers, I'm not going to be able to produce revenue for the organization. This is not typically going to pick up the scenario where people are afraid to use your services or shop at your place of business because they're concerned about how you store the information. Talked a little bit about privacy notification, the cost to hire that team, and to figure out how to notify in each of the states or in the 57 countries that you have to notify. Those costs can be picked up. Crisis management expenses. So most companies are not equipped to respond to potentially thousands of phone calls that you might receive following a breach. So coverage can pick up the cost of a call center or a PR firm to help you get through that storm. And then we also touched a little bit on credit monitoring services. Right now, we're only seeing about 20% of the people that are offered this type of service picking it up, but it's still very expensive and can fairly easily be picked up in a policy. Then moving along to other considerations that are not on the typical cyber insurance menu. Pay careful attention to retroactive dates. Most cyber policies are going to restrict coverage to breaches that occur after a specific date. This is usually the inception date of the policy, and since so many breaches go undetected for long periods of time, this is something that should be closely negotiated. Unencrypted devices. Many carriers are going to exclude coverage for unencrypted devices. And this can be a real issue for companies with employees bringing their own device to work. Regulatory coverage. We talked a little bit about that, but there's all different types of regulatory coverage available in the marketplace. Some will pick up defense only. Some will pick up defense and fines or penalties. And then taking that a step further, some is going to pick up specific agencies, and some will be more broad that covers all of the agencies. So no two policies are alike. The cloud. Everyone I know is certainly using the cloud at this point in the game. And the question becomes, are you covered if there's a breach by a cloud provider? So you might collect all of this information and store it in the cloud. And many of the people that I speak to initially believe that if there's a breach and it's the fault of the cloud provider is going to sweep in and save the day. And that's not usually the case, contractually or legally. And taking that one step further from an insurance perspective, it may or may not be covered, something you need to consider. Sublimits. So most of these policies will start with a particular limit of third-party liability, which we talked about before. So we have clients that might buy a $20 or a $50 million limit of liability for that third-party coverage if they're sued by others. On the first-party side, most of the time, those limits are sublimited. So you might only be able to buy $5 or $10 million of business interruption, or you might only have $1 million of regulatory coverage. Very important to keep your eye on that. Next thing I had on my list, some of the more progressive carriers are offering proactive risk management services. So they'll do penetration testing. They'll do notifications of kind of the hot things that are happening in the breach world. That's relatively new, and it's become increasingly important for companies trying to protect themselves from having a claim in the first place. And then finally, and I alluded to this in a couple of my comments previously, cyber insurance is relatively new coverage available in the marketplace, and there is no standard form available. So it's really important that you take the time to understand your company's unique risks, as well as the new and unique policies available to protect your organization.
So Chris, that's a lot of great info. My question to you is, as a business, how does you and or your agency or other agencies, how do you help us understand and recommend the right policy for us with so many different things? Do you come in and do you do risk management? Do you just ask questions? What's the process if I'm interested in learning more?
Hey, could I add something to Debbie's question? I just want to add something to Debbie's question, which is that, you know, you talk about these progressive new things that involve doing risk management, doing pen testing, doing things like that. Those things which are done by the carrier or with the carrier give a whole bunch of information to the carrier. And each of those things is a potential hook for a denial, a claim denial, if it's information that goes to the carrier. So a lot of those new progressive innovations that you're talking about, that the carriers are just trying right now, are going to be, I'm just throwing out for your response, a source of carriers going against the insureds when it comes to claim denial.
So that's an interesting point, and what we usually recommend is that what happens with a lot of those resources, especially with the penetration testing, is that you can get your attorney involved and have them deal with that interaction, because it is a third party. It's not the insurance companies doing the pen testing. So you'd want your attorney to be managing that process to make sure you keep that client attorney privilege. Getting back to the previous question, yes, we sit down with our clients and we talk to them and try and understand what they have going on at their organization. What type of information are you storing? How are you protecting it? What kind of processes and procedures do you have in place? You know, how much can you afford to take on in the upfront cost scenario? And once we have a clear understanding of the risks associated with a given company, then we go out to the marketplace and we look at that a la carte menu and we negotiate the best coverage based on the needs.
We did get one question from the audience, and it says, what cyber carriers do you recommend?
So I get that question a lot. It really depends on the type of risk. There are certain carriers that do a great job with, you know, healthcare related risks. So early on, I really started doing a lot of business with, you know, healthcare IT based companies that were storing information for hospitals and doctors. So there's a few carriers that really like that risk. And then there's other carriers that are more focused on, you know, other industries. Some carriers will not touch retail and hospitality, and other carriers almost exclusively focus on it. So, you know, 10 years ago, there was only a couple carriers playing in this market, and now, you know, just listen to the polling that you did earlier. Only 30% of the companies are buying this coverage, and none of them have had claims. So thus far, it's been pretty profitable for the insurance marketplace, and there's a lot of companies getting involved. So a lot of competition, driving prices down, and you know, making for a very interesting marketplace.
Hey, Chris, I mean, I wanted to get your take on Beasley. I know we've worked with them a lot, and I've always been impressed with them. And one of the things I like about them is they've got very helpful, proactive resources that they offer their insureds before an incident ever happens, and there's a lot of cyber awareness bulletins that the clients receive. I've noticed that the forensic firms and law firms that are on their panels are, you know, fairly reputable and well respected in the various areas. I don't know what your thoughts are on them. And you guys, you really see the whole universe of them, and you're the expert, but it's I've dealt with a few, and that's been one that I've been pretty impressed with.
So yeah, Beasley is a leader in the pack. They are one of the 2 or 3 companies offering those proactive risk management services. They continually win awards for their program and proactive approach. They're a very good carrier. They're not right for everyone, but we do a tremendous amount of business with them on the cyber side.
Okay, a lot of great input there. Kevin, any more questions?
Not right now, Debbie. That's all I have.
Hey, Debbie, can I raise one quick question, Chris?
Sure, go ahead.
So, Chris, can you talk a little bit about prior acts coverage, just to explain to people what it is and why it might be important for them to explore it in the area of cyber coverage?
Sure, and I touched on this with the retroactive date. Most of these policies, when you go out and buy a policy, they're going to say, let's say you buy the policy today, right? So today is March 23rd. You're going to have a retroactive date or a prior acts limitation that says anything that happened before the date of this policy beginning is not going to be covered. So you might buy the policy today and 6 months have a claim and find out that that breach actually occurred February 1st. There's no coverage if you have a prior acts limitation or a retroactive date in place. So this is really important, especially considering the latency of finding out that there is a breach or that your system has been taken advantage of.
Yeah, I would say that's a real critical key, because you always hear, especially in the target, and probably you guys know off the top of your head the actual number of days they were in the systems before they were detected. So if it was retroactive, it wouldn't go back to, it wouldn't cover anything that happened, because it wouldn't have retroacted back a year or 285 days or whatever it was. So a very important piece of information for consideration by everyone. Any other questions from the panel regarding that, John or Al? No. Okie dokie. All right, we're getting down on time here, so let's go to the next question. I really want to save some time for the last question. So real briefly, Al, if you can, explain to the audience when to use a forensic firm, when you should engage a forensic firm if you have a breach, how and or why and how you should incorporate outside counsel before you engage that firm to assist.
Sure. So if you have an incident and it involves some form of a cyber attack or something with your system, you're seeing some sort of unusual activity, it's a good idea to engage an outside third-party forensic firm immediately to help. Why do you want the forensic firm versus doing it yourself? Because it provides some level of independence to say that you've had a third party actually review this. You know, your information security department will have its own self-interest, when this incident occurs, to say, there's nothing really going on, or don't worry about it, and really playing it down. Having a third-party forensic firm, though, helps provide potentially regulators or affected individuals a sense that you had somebody else look at it. In terms of how you incorporate outside counsel in the process, there's some pretty good case law out there right now where courts have held that where the forensic investigation was done at the direction of counsel for the purpose of giving the company legal advice about their compliance with privacy and data security laws, then the work product that was developed by the forensic firm is protected by the attorney-client privilege and or the work product doctrine, which is a fancy way of saying that when the forensic firm creates all these pretty negative documents about the company, because remember, at the end of the job, the forensic firm is going to provide a deliverable that says, here are the 5 things you were doing wrong that led to this happening. Here's what you need to be doing in the future. Here's how it was remediated. And if a plaintiff's lawyer, quite frankly, were ever to get his hands on that document, that would essentially be a roadmap for how they're going to bring the class action lawsuit. So you want to be able to argue that that document's protected from discovery. So that's why it's important to engage counsel. You can't always make the argument, but it puts you in a really good position to be able to do that. So how do you do that? Step number one means when you have the initial MSA or SOW, you have in there that the engagement is being directed by counsel for the purpose of allowing counsel to give legal advice about the company's compliance with privacy and data security laws. You make sure that the scope focuses on whether personally identifiable information has been affected. Counsel needs to be on the initial kickoff calls and then any important calls thereafter. The draft reports and status reports, counsel should be reviewing those, and with the final draft report, quite frankly, with a lot of our clients, we review the draft report. The law we do, meaning Shook reviews it, rather than the client reviewing it. We provide comments back to the forensic firm before the client even sees the next draft or even the final draft. And then you also have to incorporate that final report into some sort of a legal memorandum, because it's not just a papering of the file. You actually have to show that what the forensic firm was doing was to be able to give your lawyer legal advice. And the way that works is the forensic firm telling you, was personally identifiable information affected or not, which then allows the lawyer to say, okay, PII was affected, and therefore here's what the law requires you to do. And so it's blended ultimately into this legal memorandum that's delivered to the client. The last thing I'll just say is that it's good to be thinking about this now. Don't set up the relationship with the forensic firm the moment a breach or an incident happens, because negotiating that contract can take days. I've even seen it take weeks in some instances, and you need immediate help when that happens. And quite frankly, they'll have you over a barrel on rates if you're trying to negotiate with them after the incident has already occurred versus trying to do it proactively. There are some really great forensic firms that do that, so a good idea to look into that.
So do those forensic firms that you've worked with offer basically a retainer option to just be available when needed?
Yes. So one of the forensic firms I'm thinking of, which is our favorite one to work with, they do sort of different levels. Like there's a retainer, there's an agreement where you pay nothing up front, but then there's no SLA. Like they can't guarantee that they will be immediately responsible. It might take some more time before they get boots on the ground. Or you can pay a certain amount, maybe it's $30,000 or $50,000 or $60,000 a year, and then that requires that they have boots on the ground within like 24 hours or something. So it really just depends on how, what level of retainer you want to put it. Now, with what I'm thinking about, and other forensic firms do this as well, you don't use that, let's say $50,000 that you've now spent on that first year because you don't have an incident. They will often let you use it for something like a tabletop exercise or penetration testing. So it's not money that's down the drain. You can use it for other purposes.
Great.
I will add
John,
that one of the greatest. Excuse me. I was going to add one more thing on that. One of the greatest benefits of having an insurance policy is that you're not going to have to go out and negotiate with the 5 or 6 or 7 different vendors that might be involved following a breach. The carriers have pre-negotiated rates, and you'll be able to take advantage of that. And some of the carriers, not all, will allow you to select your own vendor.
So I think that part is huge. What Chris just said at the end there, I think is yeah, the ability to select your own vendor, because if you've got a relationship with a good vendor, whether it's a forensic firm or a law firm, whoever it is, you want to make sure that you get to choose them. So think about that at the time when you're purchasing the policy and selecting your policy.
Great chime in there, Chris. I was actually going to go to you, and I said John, but I meant Chris, and just ask from your involvement. The stats that we had at the beginning, only 33% of people have cyber insurance. How many times, I guess, when you've been engaged, have forensic had to be involved from an insurance claim perspective or litigation that you've seen, Chris, or any of you?
100% of the time that I get that phone call that a breach or they believe a breach has occurred, we have a forensics team in, usually within 24 to maybe 48 hours.
Okay.
That's the first cost that you incur, right? So they'll assign a claim adjuster, and then typically someone's going to be flying over, from wherever they are to come in and try and figure out what happened and to stop the bleeding.
Great. John, do you have anything to chime in, or do you want me to move on to the next item there?
Yeah, I'll just offer a dissenting perspective on it. Which is that I use all the major forensics firms, and many of them are great. They're good for different purposes, and you don't necessarily want a relationship with one, beforehand, and having the ability to draw on the ones that the cyber risks carrier has negotiated with is important. But the fact of the matter is that it's in the minority of breaches, and I think having handled multiple breaches every week since 2005, it's the minority of breaches. You have many cases. I'm dealing with a few cases right now, and some of you have probably experienced this, where your payroll departments have been hit with an email from the CEO, and the email from the CEO says, upload the W-2 files from 2015, and bingo, tax fraud. And the fact is, you found out what happened. You don't need an external forensic firm often to do it. Sometimes you do on those. But the fact is, a lot of the time it's unnecessary. A lot of the time breaches can be managed for very little. But that's just to give you a different perspective on it. Anyway, on to other questions perhaps.
Yeah, good info. Kevin, do we get any questions in that area?
No, we don't.
No questions? Okay, great. Guys are just banging up, no questions. Important, last one, John, I'm going to defer this one to you. We got about 8 minutes left for this webinar. So important considerations as security moves beyond the breach of just confidential information to availability and integrity information. John, what are your thoughts on that?
So another big change that we're seeing is, if you look at the winning criminal exploit, the business model that's really working, that's really taken off, according to Kaspersky and other firms, is ransomware. And we see incredible amounts of distributed denial of service attacks. In fact, the entire Internet of Things attacked the Internet and brought it down a little bit with a thing called the Mirai botnet last year. So what are you seeing there? You're seeing not a breach of confidentiality. You're seeing instead a denial of availability. Ransomware is where they come to you and they say, you know what? We just encrypted all your stuff. And if you want it back or you want it to be available, then you better pay us. And it's a really simple transaction. You don't have to sell anything on the dark market, the dark web, or any of those international exchanges for the personal information. It's just pay me some Bitcoin, and it's usually a small amount now, but it's getting bigger and bigger and bigger. And hospitals and others have been paying up. There are many cases where you need to prepare for that. So the ways you prepare for those things are often, the availability attacks are often different. It focuses on the backups. It focuses on being able to get back up and restore from your backups. Hopefully your backups haven't been infected as well. Most of the ransomware people are relatively impatient, so they sort of don't wait until the stuff gets into your backups. We have clients with lots of interesting backup strategies using other media and so forth to foil them if they try to get into it. But that stuff, where some of the insurance will cover that, because some of the insurance has been focused, if not on privacy events. There's often a privacy event exclusion in some of these, but they can be focused not on that, but on business interruption. So you need to look at cyber in terms of business interruption as an important component of coverage, but you also need to think about whether your business allows you to restore quickly enough from the backups all the various people who need access to your business. And in complex environments like healthcare environments, often it doesn't. And so there's another big thing that's happening. which is attacks against critical assets, digital assets of companies, targeted attacks by competitors, by nation states that own competitors of your companies. The greatest transfer of wealth in the history of the world, targeted cyber attacks. Those things are very often not covered by many available forms of insurance at all. And those things often relate to the most important crown jewels in your company. And what's really, really important for many of your companies, it may not be so much that the personal information is your crown jewel. For some of you it is. For many of you it is. But for many of you, there are other things that are your crown jewels. And are you asking yourself, what am I doing to protect against that? Sometimes there's coverage for it, sometimes there isn't. You've got to protect against it in other ways. And so the way you've got to protect against it is cybersecurity, really. And finally, I'll get to one other big change that we're going to see a lot more of. There are people who are coming in and changing the data. That's the integrity of the data. So they go after the availability. They go out. They do targeted attacks on these knowledge assets, and then they also go after the integrity of the data. And so you see, you're going to see more and more of that as many of your organizations move toward data-driven, being data-driven organizations. That people will come in and whether they do it for a ransom, or they do it just to screw your business up, or they do it for through some other economic proposition, it'll be a question of your data being destroyed or your data being altered in ways that interfere directly with its utility to you. So those are some of the things that are happening that are going to make this a wilder and wilder area. Most of the cyber risk coverage that Chris was talking about is focused on these privacy events, so thought it would be good to throw in these developments as well.
Hey, Debbie, I don't think any discussion of ransomware would be appropriate without Mr. Bergio telling us his experience with a client in this area that, to me, is one of my favorite stories in data security lore. I don't know, Chris, if you know which one I'm referring to.
That's great, and the insurers are open on the ransomware front, very open to paying the ransoms and maintaining a little Bitcoin on the side. Go ahead, Chris.
Yeah, I think you're talking about the Russian hacker story.
Yeah.
And we had a client get an email on a Friday afternoon that essentially said, we have control of your servers, wire us $50,000 within 24 hours, and we'll leave you alone for a year. So I get this call, and my client says, well, what do I do? So we got the Secret Service, we got the FBI, we got the carrier involved. Long story short, Secret Service and FBI couldn't do much for us, and it was determined by the carrier that they were going to pay the ransom. So they wired the money, and they paid it, and we thought we were done with it. About 6 months later, I get a call from the same client. Dear sir, this is the Russian mafia. We've got control of your servers. Wire us $50,000, and we'll leave you alone for a year. The client calls me and says, well, what do I do, Chris? And I said, well, yeah. I said, well, we just did this 6 months ago. Why don't you just respond and tell them that you paid it 6 months ago? So he responds, dear Russian hackers, we suffered this issue 6 months ago. We paid the ransom. What's up?
Our contract is expired.
This is a true story. I was involved with this claim. The response, and I'm paraphrasing, was, our apologies, please disregard the previous email.
Excellent.
So apparently there's a billing department of hackers, right?
It was an administrative problem. They had a problem in their billing department, exactly.
I think it just drives some of the point that these are professional organizations, and they're in this. It's a profitable and professional organization, and it's run as such.
Right, but that's not to say that they're all like that, because there is the case of the hospital that paid once, and they said, okay, we enjoyed that. Now pay us again, or we're going to do the same thing to you, even though you just paid us. So there's no guarantee of honor among thieves, but you often find it.
So with that, we are at 3 o'clock. I will add that one of the next quarter's upcoming sessions, one of the other months, will also be focused on ransomware, so definitely more information to follow. Kevin, did we have any questions come in real quickly before we sign off on this one?
No, Debbie, we're all caught up.
We're good? All right, well, I want to personally thank Chris, John, and Al for your attendance. And your participation and everyone who attended. It's been a lot of great information. I found it extremely helpful, and hopefully everyone else did as well. We also will, as I said, everyone that was in attendance will be receiving a copy of the slide deck, which has all of our contact information on it. So please feel free to reach out to any of us. And Kevin, you can just go to the last slide for any additional information on Champion. One more. You can follow us on the following social media avenues. So thanks again, everybody, for your time. I know we're 1 minute late, but hopefully it was worth your time. Everyone have a great day. Thank you.